is concerned, with respect to the jurisprudence of company law is concerned. This case law can be applied by CA final students in many chapters, wherever wherever jurisprudence is questioned, and any questions relating to the powers of the board, any questions relating to the minority rights, any questions related to majority rights is coming into this very important case law, and it has been specifically applicable to the oppression and mismanagement chapter of your syllabus. And this case law is basically upholds the law relating to the majority rule. Whatever decisions the company takes is run by the majority, that is the edifice of the company jurisprudence. Always the will of the majority will apply over the right of the minority shareholders. But at the same time, minority shareholders will also get some proceeding rights when it comes to the ultraviolet activities, wrongdoers in control, fraudulent activities, oppression and mismanagement is there. So this case law basically says that always the rule or the the power or the wishes of the majority will prevail over the wishes of the minority, of course, but at the same time minority shareholders has also their own remedies specifically into the company's jurisprudence. And also another thing which has been stated in Force versus Harbotel is the court will not usually interfere in the internal affairs of the company. The internal management of the company is best with the majority and best with the directors of the company. So Force versus Harbotel is one of the cardinal and edifice case law which specifically says that the decision of the majority will always prevail over the right wishes of the minority shareholders, with some exceptions which is stated in the case law itself. Friends, this Force versus Harbotel has been widely used whenever there is a dispute between the minority vis-a-vis the majority shareholder is concerned. And in India, Rajmundry Electric Supply Company Limited, Corporation Limited case law, that is Rajmundry Electric Supply Corporation versus A. Nageshwar Rao in 1955 has also have some reference with respect to the interference of the court into the internal affairs of the company, and with specific reference to some minority rights is concerned. So altogether these case laws can be used in your oppression and mismanagement chapter. I'll repeat again, the crux of Force versus Harbotel is point number 1, always the rights of the majority or the wishes of the majority will prevail over the wishes of the minority. Point number 2, the court will not interfere into the internal affairs of the company. The internal affairs is vested with the directors or the majority shareholders of the company. Even though there is an issue, there is some question of rights violation is concerned, the perfect person to file a petition is the majority shareholders. So I will explain once again the whole concept of Force versus Harbotel in one line. Always the wishes of the majority shareholders will prevail over the minority shareholders, except in the case of ultra-virus activities, except where the wrongdoer is in control, except in the case of fraud, and except where there is oppression and mismanagement happening in the company.